Welcome to the Deep Dive. Today we're looking at something, well, a bit unusual in law, a piece of legislation specifically designed as a bridge, almost like a legislative time machine. We're diving into the Road Accident Fund, Transitional Provisions, Act 15 of 2012.
That's right. It's not about creating new rights, fundamentally, but about managing a shift.
Exactly. It deals with a very specific group of people and their legal claims, claims that got caught when the rules for compensating road accident victims changed drastically. Our sources show it was signed off, ascended to, December 2012, but it actually commenced on February 13th, 2013. That date is key.
It really is the pivot point. The whole purpose of this act was to sort out the claims that were already in the system, or should have been, before the big RAF amendment back in August 2008. So it gives transitional measures for, like you said, a specific group, these third parties, whose claims fell under the old limited rules before 2008.
It's basically a mechanism to funnel those older limited claims into the new system.
Precisely. To manage that transition smoothly, or, well, as smoothly as possible.
Okay, let's unpack that then. We need to understand the landscape. What were these two different eras, the old and the new, and who exactly were these third parties caught in the middle?
Right. The definitions are crucial here. First, you have the old act. That refers to the Road Accident Fund Act, the 1996 one, but specifically how it looked before August 1st, 2008. And that version had certain financial caps on compensation.
Okay, the pre-2008 rules. Got it.
Then there's the new act. It's technically the same 1996 act, but as it stood after the amendments took effect on August 1st, 2008, this new version changed things significantly, especially around what we call general damages compensation for pain and suffering.
Right, the non-pecuniary loss side of things. And the third party, who fits that description under this specific transitional act?
Yeah, the definition is very, very precise. It's someone who had a legitimate claim for compensation under the old rules. And crucially, their claim was subject to those old financial limits, like the cap on general damages or loss of income that existed back then. The final piece is timing. When this transitional act kicked off in February 2013, their claim couldn't have been finished. It hadn't prescribed, run out of time legally or been finally settled or judged.
So these are the people whose cases were effectively stuck mid-process when the rules changed underneath them.
Exactly. Their files were still active, still unresolved.
Okay, now here's where it gets really interesting for me. The act didn't just force everyone onto the new rules. It gave these third parties a choice, a really big choice, but with a tight deadline.
That's the absolute core of it, Section 2.1. The default position, if you like, was that your claim would automatically fall under the new act because of this transitional law. If you did nothing, you were in the new system.
Default is the new rules.
Okay. But, and this is the critical part, you could choose to stay under the old rules. To do that, the third party had to tell the fund very clearly and without conditions, expressly and unconditionally is the legal phrase, using a specific official form that they wanted their claim to remain subject to the old act.
Wow. So you're deciding which set of compensation rules applies to your potentially life-altering injury claim.
Yeah.
And you had to use a special form. What was the deadline? How long did people have?
1 year. Just 1 year from when the act started.
1 year. From February 2013.
That's it. So by February 2014, you had to have submitted that form correctly and unconditionally. If you missed it, or if the form wasn't quite right, bang, you defaulted into the new regime. No second chances.
That seems incredibly short. I mean, think about someone recovering from a serious accident, maybe dealing with brain injury, or just navigating the legal system for the first time. 1 year to make such a fundamental choice.
It is undoubtedly a very strict time frame. And the legislature recognized that potential unfairness for certain people. So there's a provision that helps if the third party was facing what's called a legal impediment. Think of someone who's a minor, or someone declared mentally incapable of managing their affairs. For those individuals, the 1 year clock to opt out only starts ticking after that impediment no longer exists. So a minor would get a YIM after turning 18, for instance.
Ah, okay. So there's a bit of a safety valve for vulnerable individuals. That's important context.
It is. It shows an attempt to balance the need for finality with individual circumstances.
Right. Now let's look at the practical side. If someone defaulted into the new act regime, or maybe they actively chose it, what were the immediate consequences? How did it change their claim? Let's start with timing.
Well, the first big thing is that the act sort of rewrites history for administrative purposes. It says that the third party's cause of action, basically, when their legal right to claim began, is deemed to have arisen on August 1st, 2008.
Even if the accident was years before?
Yes. Even if the accident happened, say, in 2006. For the purposes of applying certain parts of the new Act and the 2005 Amendment Act, the start date becomes August 1st, 2008. It standardizes the timeline for these transitional cases.
Okay, standardizing the start date. What about the money? Particularly non-pecuniary loss, pain, and suffering. That was the big change in 2008, wasn't it? How did that play out here?
It played out with a very, very significant initial restriction. Under this transitional process, if your claim fell under the new Act, your compensation for non-pecuniary loss was initially capped at a maximum of R25,000.
25,000 Rand. That's incredibly low for potentially serious lifelong injuries.
It is a very low cap,
Yeah.
and it was, clearly designed to manage the fund's financial exposure to this backlog of older claims being brought into the new system.
So how could someone get past that R25,000 cap? Was there a way?
Yes, but it involved another major deadline, another hurdle. To get more than R25,000 for pain and suffering, the third party had to prove they suffered a serious injury as defined under the new Act's regulations. And they had to do this by submitting a formal serious injury assessment report prepared according to Regulation 3.
Okay, a specific medical report. What was the deadline for that?
2 years. They had 2 years from the commencement of the Transitional Act, so until February 2015 to get that report submitted to the fund. And just submitting wasn't enough. The fund then had to formally assess that report and agree that the injury met the serious threshold according to those regulations.
So let me get this straight. 1 year to decide if you even want to be under the new rules, potentially capping your general damages severely. And if you do end up under the new rules, you then only have 2 years total from the start date to get complex medical evidence submitted and accepted to maybe lift that cap.
That's the timeline. 1 year for the opt-out choice, 2 years for the serious injury proof. Miss either, and for general damages, you were stuck at that R25,000 maximum. It forced a very rapid pace.
That pace respects no time at all, especially for someone seriously injured. Okay, moving on from the non-pecuniary cap. The transitional rules also forced certain deductions from the final claim amount, right? To prevent double compensation.
Yes, absolutely. Section 21C lists specific amounts that must be subtracted from the third party's claim under this transitional process. It's about ensuring the fund isn't paying for something already covered elsewhere.
What's the first category of deduction?
First, anything the claimant already got directly from the person legally responsible, the owner of the vehicle, the driver, or maybe the driver's employer if they were on duty.
Makes sense. What else?
Second, any amounts that were already paid or were due to be paid to suppliers, think hospitals, doctors for services provided to the claimant under the old Act's provisions, specifically Section 17(5). Third, pretty straightforward. Any interim payments the fund itself might have already made to the claimant while the claim was ongoing, those advances get deducted from the final settlement.
Okay, so deductions for payments from the wrongdoer, old supplier payments, and fund advances. What's the last main category?
The fourth one covers compensation received from other statutory schemes. The claim has to be reduced by any benefits paid under laws like the Compensation for Occupational Injuries and Diseases Act, COIEDA, or the Defense Act, or similar laws covering this NDF. It reinforces the idea that the RAF is often the payer of last resort, particularly when things like workplace injury compensation are involved.
And the claimant has to be upfront about receiving these other payments.
They absolutely do. There's a specific requirement for the third party to provide a written declaration under oath on yet another prescribed form detailing any compensation they've received from those other sources. It's a check against non-disclosure.
Right. Lots of forms, lots of deadlines. Now, procedure-wise, did the Act offer any relief to make things a bit easier for these older claims already in the pipeline?
It did offer a couple of procedural concessions. One was about the initial claim form. If the claimant had already properly lodged their claim with the fund using the old RAF-1 form before this transitional act started, they were specifically excused from having to submit a new RAF-1 form under the new Act rules. It saved them that bit of administrative duplication, which was helpful.
Okay, that makes practical sense. Was there anything else on the procedural side?
Yes, something quite significant regarding court proceedings. If a claimant had initially filed their lawsuit in a magistrate's court, perhaps because the limits under the old Act made that seem appropriate at the time, they were given a special window to withdraw that action and then refile it in a high court. They had 60 days from the date of withdrawal to institute the new action in the higher court.
Why allow that switch? And what was the protection during those 60 days?
Well, high courts generally handle larger, more complex claims, which many serious injury cases are, especially once the old caps were potentially lifted. So it allowed claimants to get their case into the appropriate level of court. The vital protection was this. During that 60-day window between withdrawing from the magistrate's court and filing in the high court, the fund was explicitly barred from raising a defensive prescription.
So they couldn't argue, sorry, you're out of time now, just because the claimant was moving the case to the right court.
Exactly. It was a 60-day immunity period against the time bar defense, purely to facilitate moving the case to the high court without penalty, a crucial procedural safeguard.
That really is important. Okay, let's get to one of the biggest impacts of this whole act. What happened to the liability of the people who actually caused the accident? The driver, the owner, the employer.
This is perhaps the most definitive outcome for those individuals. Section 21G is crystal clear. From the date the Transitional Act came into force, February 13th, 2013, the owner, the driver, and the employer of the driver involved in the accident are completely absolved from any liability to that third party.
So the fund steps in, takes over the claim under these transitional rules, and the original driver or owner is legally off the hook.
Correct. Their personal liability towards that specific third-party claimant is extinguished by the Act. The fund becomes the sole defendant, the sole source of compensation, and just one small related point. The Act also protected suppliers, like doctors or hospitals, who had provided services before the transition. It stated that the new tariffs and rules under the amended Act wouldn't apply retroactively to their claims for payment for those pre-transition services. Their existing claims were preserved under the old rules.
Got it. So, wrapping this up, we've journeyed through a really focused piece of legislation. The Road Accident Fund, Transitional Provisions Act of 2012, was essentially, like you said, a legislative bridge. It took a specific group of old limited claims and moved them into the post-2008 system, but with some very strict conditions: that 1-year opt-out, the 2-year serious injury-proof deadline, mandatory deductions.
It really was a one-time cleanup operation. Its goal was to bring finality to those lingering pre-2008 limited claims, quantify them under the new framework with those caps and hurdles, and crucially, draw a line under the personal liability of drivers and owners for those specific historical accidents covered by the Act.
So thinking about all this, the tight deadlines, the need for prescribed forms, the requirement for complex medical reports within just 2 years, it leads to a final thought for you, our listener. We saw there's some protection for those with legal impediments, like minors. But considering the sheer administrative burden and the relentless ticking clock built into this law, how might these pressures impact someone's practical ability to get justice, especially if they don't have easy or immediate access to lawyers or specialized doctors? What stands out to you about balancing legislative efficiency with individual fairness in this kind of transitional race against time?